Very good morning to all younger advocates. On the last video on Specific Relief Act 1963 as amended in 2018, a particular model case is taken under section 9, 10 and also 16 and 22. Some precedents of the High Court and Supreme Court are discussed. There in that suit the defense taken is whether the plaintiff is not ready and willing to perform his contract about limitation, and also whether the plaintiff is entitled for specific relief. These are all defenses taken in that suit. And one more defense that we have not discussed is whether the time is essence of the contract or not. As far as the time is essence of the contract or not is concerned, this is a very usual defense one takes in specific performance suits. But here that depends upon the contractual terms also, basing on the terms and conditions that are incorporated in agreement of sale. So here, as far as the issue of whether the time is essence of the contract or not is concerned, basing on the particular facts of the case, in 2008 4 ALD 781, K. Mahadevarao versus Vasta Tabassum Ghosh, wherein their lordships held that time is not the essence of the contract and there is no default clause in the agreement. So there should be compulsorily some default clause in the agreement to take this defense that the time is not the essence of the time is the essence of the contract or not. So here the totality of the circumstances will be taken into consideration, and if there is absolutely no condition to put an end to an agreement, end to the agreement in the event of default of payment of balance sale consideration within stipulated time, and to forfeiture of advance amount paid by the plaintiffs. So in this case, if these default clauses are there, the court cannot hold that time is the essence of the contract. So here the fixation of the period, that is the note, if there is time is not the essence of the contract when there is no default clause in the agreement. So these default clauses should be there, otherwise this issue will be held against defendant. Then next, in year 1977 Supreme Court 1005 Govinda Prasad Chaturvedi versus Haridatta Shastri and another, wherein the Honorable Apex Court held as follows: when a contract relates to a sale of immovable property, it will normally be presumed that time is not the essence of the contract. So in case of immovable property, it will be normally presumed that the time is not the essence of the contract. The intention to treat time as essence of the contract may be evidenced by circumstances which would be sufficiently strong to displace the normal presumption that in a contract of sale of land, stipulation as to time is not the essence of the contract. So here also same meaning, there should be some default clauses. Without default clauses, the defendant will not succeed. And another case, in another decision reported in 2008 3 ALT 144, Sheikh Mahbub Sahib versus K. Nageshwar Rao. In this, their lordships held that time is not essence of the contract where the party agreed to receive balance sale consideration within a specific time, but no consequential clause is provided in the event of default. Therefore, the time cannot be said to be the essence of the contract. So consequential clauses, default clause has to be there. So this all three decisions are same. In order to invoke the defense of time is essence of the contract, it depends upon the terms of the agreement, whether the default clauses are incorporated or not. If plaintiff fails to perform his part of the contract within a stipulated time. Then another important judgment is year 1993 Supreme Court 1742, that is Chandrani versus Kamal Rani. It is very important judgment. Chandrani versus Kamal Rani, A year 1993, Supreme Court 1742. Here a constitution bench in this case held, in case of immovable property there is no presumption as to time being the essence of the contract. Even if it is not of the essence of the contract, the court may infer that it is to be performed in a reasonable time if the conditions are from the express terms of the contract, from the nature of property and from surrounding circumstances. When in an agreement to sell the immovable property, it was stipulated that amount in part was to be paid within 10 days of execution of agreement, and the balance has to be paid at the time of registration of deed, and it was agreed that vendor would redeem the property which was mortgaged and also obtain the income tax clearance certificate, and the word only was used twice to qualify the amount and to qualify the period of payment in such amount. 10 days it was held that the intention of the parties was to take time as essence of the contract. In such a case, when the purchaser was not ready and willing to pay the amount in part as agreed before delivery of possession and income tax clearance certificate and redemption of mortgage, it was contrary to the conditions of the agreement, and the purchaser was not entitled to the specific performance of contract. So in the constitution bench also, what they held that there is no presumption as to the time being essence of the contract. Even if it is not the essence of the contract, the court may infer that it is to be performed in a reasonable time if the conditions are from the express terms of the contract, from the nature of property and from surrounding circumstances. Now next, that is one important decision, Chandrani. The another one, constitution bench judgment. The other one is K.S. Vidyanathan and others versus Vairavan, year 1997, Supreme Court 1751. This is also another important judgment. Here their lordship shall that all this only means that while exercising its discretion, the court should also bear in mind that when the parties prescribed certain time limit for taking steps by one or the other party, it must have some significance, and that the said time limit cannot be ignored altogether on the ground that time has not been made the essence of the contract. So here the little different opinion is expressed in Vidyanathan's case, that when time is fixed, that cannot be taken lightly. That is what the purport of this judgment. Then in year 2011, Supreme Court 3234, Saradamani Kandappan versus S. Rajalakshmi and others. Their lordships held in this case that the failure of the appellant purchaser to pay the balance sale consideration within time fixed clearly amounted to breach of contract, as the time for payment was the essence of the contract. The respondents were justified in determining the agreement of sale. The rejection of prayer for specific performance, therefore it is proper. Here they have taken time is the essence of the contract, because there is a time period fixed in this judgment, but there is some twist in this judgment. As seen from the principles laid down in the above decision, the principle laid down in para 27 of the judgment is only arbitrary dicta, but not ratio decidendi. Therefore, the principles laid down in the above decision is not directly binding on this court. Moreover, in Chandrani's case and K.S. Vidyanathan's case referred above, where the Honorable Apex Court, including constitutional bench, consists of 5 judges, held that the time cannot be said to be essence of the contract in the absence of any specific clause to put an end to the contract in the event of default in payment of sale consideration within a stipulated time. So in this case they held that time is the essence of the contract, and therefore and respondents were justified in determining the agreement of sale. But these are observations made by court by way of arbitrary dicta. So there are constitutional bench judgment and other judgment that time is the essence of the contract, cannot be accepted, accepted in the absence of any specific clause to put an end to the contract in the event of default in payment of balance consideration within time agreed. So, in view of these two earlier decisions, the observations made in the decision are only arbiter dicta. So, this is not followed by the court, other lower courts. While you are reading the judgments, that is precedents, you must keep in mind three very important things. That is, one is arbiter dicta, one is ratio decidendi, other is stare decisis. What are these three? So, while reading the judgment, all these three should be in your mind, but it may be difficult for starting people, but after reading 3-4 times, you will understand automatically what is this dictums is. So, now what is arbiter dicta? Arbiter dicta is that things said by the way to referring to remarks or observations made by a judge in a legal opinion that are not essential to the decision of the case, which are persuasive, but are not binding on courts. So, the observations made by court, so they are persuasive but not binding on court, that is what arbiter dicta. Then what is ratio decidendi? Ratio decidendi, the ratio decidendi is legal rule or principle that the court actually applied to the facts of the case, making it a binding precedent. Where there is a ratio, is a legal rule or principle that court actually applied to the facts of the case, making it a binding precedent. So, this ratio decidendi, where the judgments are decided on the legal principle, they become a binding precedents, because the lower courts has to follow these judgments. Then stare decisis. What is stare decisis? Stare decisis is a legal principle meaning to stand by things decided. In essence, it dictates that court should follow the precedents set by previous court rulings when deciding similar cases. This principle helps to ensure consistency, predictability and stability in legal system, and also uniformity. So, therefore, stare decisis says that the citations, the precedents and judgments of the superior courts has to be followed by the courts below. So, why it has to be followed? To avoid inconsistency and to achieve predictability and stability in legal system and uniformity. So, here under stare decisis, the same court which passed the earlier judgment and later similar facts are coming, the same court has to pass the later judgment also in line with the earlier judgment. That also applies to the same court under stare decisis. So, arbiter dicta, ratio decidendi and stare decisis. These three things you have to bear in mind while reading a judgment. It may not be possible in the initial stage, but after reading you will come to know what is stare decisis and what is ratio decidendi and what is arbiter dicta. So, after what is arbiter dicta, you can read the judgment AR 2011 Supreme Court 3234 and compare this judgment with earlier Chandrani and Vaidyanathan judgments to know which is arbiter dicta, which is ratio decidendi. So, this is important. So, as far as the time is essence of the contract is concerned, that is this thing. Next, coming to specific relief act. Specific relief act already I have covered, but again what is it in the specific relief act is very simple. The 7 kinds of specific reliefs are available under the act. What are all those 7 kinds? One is possessory remedies, recovery of possession of movable and immovable properties, 5 to 8, and 5 and 6 are immovable property. Then what about recovery of mobile property? 7 and 8 covers under mobile property. It is very simple, because recovery of only immovable property 5 and 6 are there, but what about recovery of mobile property? So, mobile property 7 and 8 are there. Then specific performance of contracts 9 to 25. So, this 9 to 25, I have covered so many, as many as I think 20 judgments, including today's 4 judgments, 4 or 5 judgments, as far as sections 9 to 25 are concerned. So, in that these sections, contents of these sections are reflected in those judgments. Please kindly read those judgments, and that also this Chandrani, Vaidyanathan judgments, if you read, you will understand entire 9 to 25 sections, because the lordships employed such a language, and also understandable language, and reflecting various contents of various sections. So, more you read these precedents, that means judgments of superior courts, it will be more aware of these sections. Next, rectification of instrument, section 26. As far as rectification of instruments are concerned, you read that section 26 in multiple choice, the instrument can be rectified under any 4 they will give. Out of 4, actual contents where under section 26 will be mentioned. That if you can only spot that answer only when you read rectification of instruments, section 26. Then rescission of contracts 27 to 30. This is also very important. Rescission of contracts, under what is the rescission of contracts, they will give 4 answers. Until unless you read what is rescission of contracts, you will not be able to answer. Then cancellation of instrument 31 and 33. It is another important. In the cancellation of instrument, what you have to remember is, I have earlier also I given an example. What you have to remember is, for cancellation of instrument, the plaintiff should be necessarily a party to the document. It is most important. If you are not party to the document, you cannot file ask for relief of cancellation of deed. You may ask for some other relief of declaration that it is void, but for seeking cancellation relief under section 31 and 33, you have to be a party to the deed, which deed you sought to cancel it. Here it is simple example is there. I will give you. One old woman was taken to registry office, and without her knowledge some gift deed was executed. Later on she comes to know about misrepresentation and fraud played for. Then she has to necessarily seek cancellation of sale deed alleging the fraud. So, she is party to the document. Only just I am giving experience in our way when we file these suits. You can't simply asking, declaring that void. Instead of that relief, you are alive and party to the document, you ask cancellation basing on fraud and misrepresentation. That is the appropriate relief. Then coming to declaratory dictis, legal character and all, already last time I told. But you have to once read this, then only in multiple choice you can spot, because they will give similar, all the answers seems to be similar, but until unless you read it, you can't spot the answer. That is very important. Then injunctions 36 to 42. So, permanent injunction, mandatory injunctions, these all where this threat of disposition, and when the injunction suit is there, incident title also we must have. Then mandatory injunction, when to be granted, when not to be granted. In the mandatory injunction, if there are accusations and laches on the part of the plaintiff, whether compensation is a proper remedy or not, these are all things are covered. But in the injunctions, what I would like to impress on you is under section 41, when injunction cannot be granted. That is an important question. Normally that will be repeated in the exams. That I will read that for your benefit. 41. Injunction when refused. An injunction cannot be granted is a bit of important question, because formed by the so many advocates who appeared in the various examinations, judicial examinations, that this question is often asked. It is very important. So, you also try your luck. Injunction when refused. An injunction cannot be granted to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit in which the injunction is sought, unless such restraint is necessary to prevent a multiplicity of proceedings. So, you can't restrain a person from prosecuting a legal proceedings, that too judicial proceedings pending at the institution of the suit in which injunction is sought, unless such restraint is necessary to prevent multiplicity of proceedings. So, multiplicity of restraint is necessary to prevent multiplicity of proceedings. Ante already number of suits వేసేసి somebody is vexing you, then it may, but otherwise normally injunction cannot be granted to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit. Then next, to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. To restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. So, in this also injunction cannot be granted. To restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. So, you can go to appellate court or superior court if the lower court grants injunction. So, one cannot restrain him from doing so. Then next, C, to restrain any person from applying to any legislative body, that you know, nobody can restrain him. D, to restrain any person from instituting or prosecuting any proceeding in a criminal matter. So, in a criminal case also you can't restrain him from filing a criminal case, any person. Then E, to prevent the breach of contract, the performance of which could not be specifically enforced. Then to prevent on the ground of nuisance an act of which is not reasonably clear what it will be a nuisance. So, it will not be clear whether it will be a nuisance or not. Then G, to prevent a continuing breach in which the plaintiff has acquisition. To prevent a continuing breach in which the plaintiff, because if the plaintiff accepts, consents, though it is a continuing breach, you can't file a suit for preventing it. Then H, when equally efficacious remedy can certainly be obtained by any other usual mode of proceeding except in case of breach of trust. So, when equally efficacious relief can be certainly be obtained by any other usual mode of proceeding except in a case of breach of trust. Then HA is clause HA inserted by the Specific Relief Act Amendment Act 2018, Act 18 by 2018, dated 1/8/2008. It would impede or delay the progress or completion of any infrastructure project or interfere with the continuous provision of relevant facility related thereto or services being the subject matter of such project. So, in this also injunction cannot be granted. This is it would be impede or delay the progress or completion of any infrastructure projects. So, their injunction cannot be granted to restrain them from constructing. Then I, when the conduct of the plaintiff or his agents has been such as to disentitle him to the assistance of the court, because this is a equitable relief and the conduct of the plaintiff approaching the court should be very important and he should be fair and he should come with clean hands. When the plaintiff has no personal interest, in the matter. So, it is a order in injunction is a order in personam. So, once he is not having personal interest, normally injunction is not granted. So, these are all up to A to J, including HA, which is added by virtue of 2018 amendment to the Specific Relief Act. This is an important question. Please kindly go through this one. And coming to other important matters as far the examination is concerned. Now we have discussed about sections 5 and 6 about possession for filing recovery possession suits under different circumstances. Then what is there for recovery of immovable property? That is what we have just now. Here recovery of specific movable property. Immovable property is 5 and 6. Two provisions are already there for recovery of immovable property. These are now recovery of specific movable properties 7 and 8. These are all very important questions 7 and 8. 7 and 8 are concerned section 7. Suppose A bequeaths land to B for his life with remainder to C. A dies, B enters on the land, but C without B's consent obtains possession of the title deeds. B may recover them from C. So, B still B is given life interest. So, title deeds he should possess, but C without consent of B he takes away. So, B can sue. So, what is this how it is this illustration is applicable to section 7 is section 7 deals with recovery of specific movable property, that is movable property in specie, namely a thing which is ascertained and is capable of identification, as for instance a particular gold chain, a specific ship, etc. Any person entitled to possession of such property can recover it in the manner provided by the Code of Civil Procedure. All that is necessary under this section is that the person should be entitled to the immediate possession of such property. In a given case, he may be so entitled even without being the owner thereof. So, here a life interest is given to the B, and C is who is a estate remainder holder. He takes away title deeds without the consent of the B, because after A dies, B should have control of that document. So, B can file a suit for recovery of that. That is what the purport of this section. So, here ownership is not necessary. Suppose certain documents are supposed to be in certain mobile properties are supposed to be in my possession, and somebody takes this, I can file. I mean, it need not that I should be a owner of that articles. Then it is clarified that a trustee may sue under section 7 for the possession of the movable property to the beneficial interest in which the person for whom he is trustee is entitled. That is so. Likewise, it is also clarified that a special or temporary right to the present possession of movable property is sufficient. The present special or temporary right to the present possession of movable property is sufficient to support a suit under this section. In other words, the right conferred by section 7 is not confined only to the owners of specific movable property. So, this out of this section you can expect some multiple choice questions. Then coming to section 8, liability of a person who is not the owner of movable property but is in possession thereof, section 8. Under section 8, any person having the possession or control of a particular article of movable property of which he is not the owner may be compelled specifically to deliver it to the person entitled to immediate possession in any of the following cases: when the thing claimed is held by the defendant as agent or trustee of the plaintiff, when the compensation in money would not afford the plaintiff adequate relief for the loss of the thing claimed, when it would be extremely difficult to ascertain the actual damages caused by it, when the possession of the thing claimed has been wrongfully transferred from the plaintiff. It is also provided that unless and until the contrary is proved, the court shall, in respect of any article of movable property claimed under clause B or clause C of this section, presume that the compensation in money would not afford the plaintiff adequate relief for the loss of the thing claimed, and that it would be extremely difficult to ascertain actual damage caused by its loss. Here, if you see section 8, so and 7, there will be some multiple choice questions. How it is under section 8 of Specific Relief Act, any person having possession or control of a particular article of movable property of which he is not the owner may be compelled to specifically to deliver it to the person entitled to it immediate possession in any of the following cases. Some 4 answers were given. When the thing claimed is held by the defendant as agent or trustee of the plaintiff, just now I have read first condition. When compensation in money would not afford the plaintiff adequate relief for the loss of thing claimed, that also I have just now read. C answer is both A and B. D is neither A or nor B. Now you have to mark answer C, both A and B, because just now I have read that clauses. Like that, in one more question under section 8 of Specific Relief Act, any person having the possession or control of a particular article of immovable property of which he is not the owner may be compelled to specifically to deliver it to the person entitled to its immediate possession in any of the following cases: when it would be extremely difficult to ascertain the actual damage caused by its loss, when the possession of the thing claimed has been wrongfully transferred from the plaintiff. So here also both A and B are the answers. So this is how they ask in the multiple choice questions in this. Similarly, the next cases in which specific performance of contract is enforceable. So when it is not possible to ascertain the actual damage caused by the non-performance, the act agreed to be done. For breach of contract, compensation money would not afford adequate relief. So these are all the answers you are expected. Then I have already said about rescission, section 27 of Specific Relief Act. There they ask rescission, court may allow the relief of rescission in the following cases: where the contract is voidable or terminable by the plaintiff, where the contract is unlawful for causes not apparent on its face and the defendant is more to blame, when the possession of the parties has been altered to such an extent that they can't be put back to their original status. D, both A and B. So like this they will ask questions. Until unless you read section 27, you can't answer these questions. A suit for declaration, when it will lie, when it will not lie. A mandatory injunction, when it will not be granted, where there are laches on the part of plaintiff and accusants. When the declaration made under chapter 6 is binding only to the parties, this is it is not a judgment in rem, so it is binding on the parties. So like that, what I will do along with this video, I will also put about multiple choice questions, about 135 multiple choice questions also I will forward along with this video. So basing on this also you prepare and try your luck, because out of this only some questions will be asked. And another thing, as far as this video is concerned, sometimes in editing some slips may be there. So in continuation it may lead to some other section. But what you have to do after listening this video, you clarify with your text, with your act, you go through the act also. So if any editing mistakes are there or not, channel will not be responsible. You have to read, go through the book also after listening this video. Now this I will forward the multiple choice questions also along with this video. I will take the scanning of this and I will forward in PDF. Now next, last time I told you to always think in your mind and utter in your mind that I can win. So this makes you evaluate if you are going through life out of inspiration, playing to win, or desperation, playing not to lose. It translates positive thinking into attitude, ambition and action. It gives the winning edge. So that's what last video I said, always have a positive mind and keep telling yourself, keep whispering in yourself, in mind and body, that I can win. So makes you evaluate if you are going through life out of inspiration, playing to win, or desperation, playing not to lose. It translates positive thinking into attitude, ambition and action. It gives the winning edge. Please have a positive attitude. So we will again meet in the next video. Thank you very much.
శుభం సంబరం జీవి మాల్ తో ప్రారంభం. ప్రతి 10,000 రూపాయల షాపింగ్ పై 149 రూపాయలకే డఫల్ బ్యాగ్, 15,000 రూపాయల షాపింగ్ పై 549 రూపాయలకి 20 ఇంచెస్ సూట్ కేస్, 25,000 రూపాయల షాపింగ్ పై 749 రూపాయలకే 24 ఇంచెస్ సూట్ కేస్, 30,000 రూపాయల షాపింగ్ పై 949 రూపాయలకే 28 ఇంచెస్ సూట్ కేస్ పొందండి. ఇంకా షాపింగ్ పై గిఫ్ట్ వోచర్ ఉచితంగా పొందండి. జీవి మాల్, విజయ్ విహార్ సెంటర్, ఆర్ఆర్ పేట, ఏలూరు.